After months of hard work, negotiations, and potentially trial, you have finally recovered on the damages in your personal injury lawsuit. You've recovered a lot, let's say 7 figures. What happens next? How is that money divided between you and your attorney? What exactly does a contingency fee agreement mean? And how do you know how much money you will actually recover at the end of your case? Today in this video, I'm going to walk through that process and describe to you what happens after a case is monetized. That means after a settlement is made or a jury renders a verdict and you receive payment for your damages. This is how you get paid and how the process works. I'm Knox Nunnally. I'm a personal injury attorney here in Houston, Texas. With my law partner, Matt Allen, we fight for the rights of injured Texans. First things first, let's talk about contingency fee agreements. These are the typical fee agreements between personal injury clients and their attorneys. It's the agreement of how the attorney gets paid at the end of the case. In summary, your attorney will only be paid if he recovers money for you. You're not paying him hourly, and if he recovers no money for you, you don't have to pay him a dime. Now that we know what a contingency fee agreement is, let's talk what deductions occur before you are paid. First, there's a deduction that's going to be made towards the attorneys. Second, there's a deduction that's being made to allow the attorneys to recover on any expenses where they advance money during the case. Number 3, there may be medical liens filed against your case by your medical providers. After those 3 payments have been made, then you as the client will recover what remains on your settlement or your judgment. Number 1, the attorney's fees. The attorneys receive, in most cases in Texas, around 40% of the recovery made by the client. In the contingency fee agreement, you would have language stating that they recover 40%. Number 2, the expenses. Your attorneys, with their own money, paid for experts to prove your case up, and in many cases, multiple depositions to be taken of witnesses. These are essentially interviews of the witnesses to help determine what the facts are in your case. Without these depositions or these experts, in many cases, your case cannot be proven or reach the value that it did. Number 3, medical liens. During the course of your recovery for your injuries, it is possible that you have had to retain medical assistance. And this either could have been done under your insurance or through other doctors. Either way, those medical providers are allowed to recoup what money was spent on those medical costs through your judgment or settlement. These liens must be paid out of the client's portion following the resolution of the case. So now that we've run down how the deductions will occur, let's walk through an example. Let's say you recover $1 million on your lawsuit. Right off the top, with a 40% contingency fee agreement with your attorneys, they would get $400,000. Now you have $600,000 remaining for you, the client. Let's say that there were $75,000 worth of expenses advanced by your attorneys in this case. So then $75,000 would then next be deducted from your $600,000. Let's say that your medical providers had liens and that the payments that you need to give them so they can recoup their money is $100,000. That leaves you, the client, with $425,000 at the end of your settlement. That's a far cry from the $1 million you received. However, I think it's important that all clients understand how the distribution of these judgments and these settlements occurs so that they know what they can potentially recover at the end of their case. Our goal with this video is to be fully transparent and not hide the ball from any client as to how these costs are divided. At Allen Nunnally, any injured party who hires us will have no better friend, and those that injured them will have no worse enemy.